a cause of action or a possession. Because what it is, I mean, I was just going to go through, and it may be convenient to do this now. What I want to, essentially, the LME rules lay down a framework under which market participants, such as Elliott, may obtain a possession in the form of a client contract. What we say as a matter of analysis is that the administrative steps that are taken in order to achieve that outcome are not themselves possessions. The conditional agreement to trade, we'll look at what the rules say. The conditional agreement to trade simply is a label to describe the administrative steps that the member has to take to log certain things on the LME's system.
Isn't the position that the contingent agreement to trade gives rise to what in the ordinary course are valuable commercial rights, contractual rights, enforceable by arbitration to recover damages if the counterparty doesn't do what it needs to do, but you say in this case there was nothing left to enforce because the counterparty had done everything it was required to do, and therefore at the time when the cancellation occurred, Elliott was not being deprived of any of those rights.
All of that.
I mean, that's where your submission goes, as I have understood.
Absolutely.
So far.
But we would also add a sort of an anterior point, is that based on that passage in Murungaro, paragraph 45, the fact that Elliott, if it is a fact, that Elliott might be able to sue its counterparty if the counterparty hadn't done what it's meant to do under the contingent agreement to trade, doesn't make the contingent agreement to trade itself a possession. The shows in action for breach might be a possession, but the mere administrative steps of logging particulars onto the LME system isn't a possession.
Well, the counterparty in this case, if it was, suppose it hadn't logged all the things onto the system, met with a claim by Elliott for damages, would say, well, there are no damages, you've not suffered any loss, because even if we had, the trades would have been cancelled.
That might well, on the facts of this case, that might well be an answer. I'm not sure that helps me, or Malone and Friend, as a matter of analysis. But as a matter of analysis, what we urge, and could I just actually very quickly walk through
surely the possession, if there is one, is the bundle of contractual rights and, if you need to divide it up this way, the expectation that once certain things that people are contractually obliged to do have been done, certain administrative consequences will follow, which will lead to a valuable right. And isn't the possession the combination of all those elements?
We would suggest, isn't that the argument? Yes.
Why is it wrong then?
Why is it wrong? Because the starting point is, can I just do it by walking...
Okay, if I'm taking you ahead of yourself...
No. I mean, essentially what our answer is that what your Lordship said, the contractual rights leads to an administrative outcome. We say it's the other way around. A contingent agreement to trade is simply a description of the administrative steps that need to be taken in order for a contractual relationship to come into existence.
Well, that's the ultimate contractual relationship, but before you get to the administrative steps, there's another contractual relationship.
There is.
And that one, you're right on the fact that this case has been executed, so in a sense that's water under the bridge, but it's still part of the package of your possession.
So there is, and we've got copies of, illustrative copies of these arrangements between Elliott and its various give-up executors and its clearing member. Yes, there is a contractual relationship there, but the contingent agreement, there isn't the possession is not said to be those contracts. Yes, there is an arrangement between client and member, and between client and executing member. But that's not said to be the possession. The possession is either an expectation, a legitimate expectation that the contract, capital C, comes into existence, or that the contingent agreement to trade is itself the contract.
Well, maybe we didn't go into it in this degree of detail with Ms. Charles-Frisk, but I understood the effect of her arguments to be, as I've just put to you, that it's a combination of contracts and arrangements.
Right. Okay.
And unless you say you can't deal with that point, that at the moment seems to me to be, whatever the history of how it's exactly emerged, that's the real point you've got to meet, isn't it?
Right. Okay. Well, in that case, yes, I'm perfectly happy to meet that as a third variant of how it's been put. And can I do it, as I say, I'd just like to run through very quickly the regime to see what a contingent agreement to trade actually involves. So it's in the trading regulations, which is in the supplementary core bundle at tab 14. And if we start at rule 2.2.3, which is on page 302. An agreed trade shall constitute an agreement, the agreement of the terms of a transaction for the purposes of enabling contracts to be formed between each clearing member, that is, party to the agreed trade or responsible for the clearing of the agreed trade, and the clearing house, subject to and in accordance with the acceptance criteria of the clearing house. Or, and we don't have to worry about B because that's not engaged here. And then after B, an agreed trade shall not itself constitute a binding contractual agreement. And we go on then to 2.5.1 over the page.
Well, not a binding contractual agreement unless and to the extent otherwise specified, which might take you to the provisions about contingent agreements to trade.
Well, yeah, yes, which is where we're going. Sorry. So over the page 303, 2.5, execution of trades on the inter-office market, where an agreed trade is made in the inter-office market, otherwise than when it is made by a registered intermediating broker, the following process shall apply. Upon the agreement of an agreed trade in the inter-office market, the parties to the agreed trade shall become bound to a contingent agreement to trade. Now, just pausing there for a moment, that in our submission is relevant to the indicia for a contract, because plainly a contingent agreement to trade is an arrangement between two parties who have, through their framework agreement, whatever it may be, agreed to trade with each other. The client has a clearing member. The clearing member has agreed to deal with that client because he's happy with that client's creditworthiness, whatever it is. You can't assign a contingent agreement to trade because a contingent agreement to trade is simply a succession of arrangements between that client and that member that need to be entered on the LME's system. The client couldn't then assign its right to require the member to enter those particulars to some other party because the member has not agreed to deal with anyone other than the client with whom it has this, whatever it is, its framework client agreement. So it can't possibly be an assignable asset. It is simply a label, the contingent agreement trade is simply a label to describe what we call the administrative steps that are required to bring about a contract.
I take your point about assignability, which I think about but it is a contract. Are you making any point other than that it isn't assignable because of the personal nature of the steps that need to be taken?
Well, because it's not assignable, it has no economic value in...
well, that comes through whether it's a possession, but I just want to be analytically clear. At one point I thought you were saying it wasn't even a contract, it's simply a bundle of administrative steps.
Yes.
But it's a contract between two parties under which one of them undertakes to do those steps.
It isn't, with respect.
Why not?
Well, because the only contract between the parties is whatever the framework agreement that exists between the clearing member and its client, under which the clearing member agrees to act for the client in order to clear transactions. The contingent agreement to trade is a creature of the rules. It's not a creature of any negotiation between member and client. And what it constitutes is, and we're just about to get to that.
Okay, why don't you go on, yes.
Yeah. So 2.5.1, we looked at A, and then at the top of the next page, you'll see D and E, which provide that cleared contracts automatically and immediately are formed between the clearinghouse and each member that is party to or responsible for the clearing of the agreed trade, subject to and in accordance with the clearinghouse rules. And then the contingent agreement to trade shall be discharged. So what the member's responsibility under a contingent agreement to trade is simply responsibility for entering the details onto a system, which are then described, maybe best if we go on to 2.6. Yeah, I'm getting there. 2.6 over the page, 3A5, formation of client contracts, where an agreed trade is made between a clearing member and its client, or the client of a clearing member and any other person pursuant to an arrangement where the clearing member is to be responsible for the clearing of the agreed trade, and upon execution of the agreed trade, one or more cleared contracts are formed between the clearinghouse and the clearing member, and then a back-to-back client contract shall be automatically and immediately come into effect between the clearing member and the client, having the same terms as the cleared contract and having the same direction as the cleared contract, such that, and then the back-to-back arrangements are described. And then over again at 307, one gets to the real content of the contingent agreement of trade. At the very bottom of page 210, the terms of a contingent agreement of trade shall be as set out below. With A isn't applicable, over the page B. Where only one party to the contingent agreement of trade is a member, the member shall be responsible for submitting the particulars of the agreed trade into the matching system in accordance with Regulation 2.10.1A2, ensure that its terms of business with the other party, being a client, specify that any contingent agreement to trade shall come into effect pursuant to such terms of business and shall incorporate and be subject to these rules, and oblige the other party to become bound to the contingent agreement to trade on the basis that the other party's obligations shall be to become bound to and perform the client contract that shall come into effect in accordance with the Regulation 2.6 upon execution of the agreed trade. And we may just look at 2.10.3. In the event that a member that is a party to a contingent agreement to trade fails to fulfill its obligations to submit the particulars of the agreed trade into the matching system within the timescale specified in Regulation 3.5, the member may be subject to disciplinary action and so on. The consequences are then set out. The time specified in Regulation 3.5, it's in a different bundle and I won't take you to it, but if for your note, it's Supplementary Reference Bundle 2, tab 21, page 405. The time specified is 10 minutes. Or, if the market isn't open, within, I think, 10 minutes of the market opening. the contingent agreement to trade is a thing of passing existence. It can't properly be described in any meaningful sense as an asset, because all it involves is an obligation on the member to enter certain particulars in a system for that client. Yes, consequences may flow from not doing so, and those consequences may be shows in action. But the requirement to enter administratively details on a system can't be regarded as an asset in our submission. So that is essentially why we say that the divisional court's ruling was correct. The analysis of the law in relation to, as I say, Cheney and in relation to DePaul in paragraphs 236 and 237 are correct. My learned friend has referred to various other cases, Boroniowski and I think Kurban. Those are all cases which are, in a sense, analytically analogous to the division. Well, sorry, why they are distinguishable is analogous to why the divisional court accepted our argument on DePaul and Cheney, which is that they all involve situations where somebody is claiming a legitimate interest in relation to an asset that already exists. And that is not this case. The ultimate asset that Elliott doesn't have is the contract, the client contract under which it gets a payment. That never existed. So it can't claim that it has a legitimate interest in something that never existed. And it can't claim in our submission that the contingent agreements to trade constitute possessions for the purposes of Article 1 of the First Protocol.
Mr. Craig, can I just draw your attention to the time?
Yeah.
I haven't worked out how much time on her reply, rather how much she had in the first place, and how much she has now lost by overrunning. But she's certainly got some time left. And you're beginning, I don't know how much more you have to say on A1P1, but there are at least two other aspects to it.
There are. My lensman took 6 hours in opening. I would be getting up to 6 hours by 12:30, which then leaves half an hour, which would have, by 1:45 actually, 1:45, which would leave 15 minutes to be balanced between us, because if she had 15 minutes, then she'd have 6¼ hours and I had had 6.
Well, I haven't. I'm sure you've carefully looked at the arithmetic. I think, speaking for myself and my lord, I think it would. My lord's. There may not be much she needs to deal with by way of reply because she was very full.
Yep.
But I think that's putting it pretty tight from her point of view. Maybe she's relaxed about it, delighted only to have 45 hours. But I think all I'm saying at the moment is get on with it. Yes.
Sure. Okay. Will do. I think you've got the thrust of our submission. Could I just make one point? In the course of oral submission yesterday, my Lord Justice Singh asked in relation to the argument that the contingent agreements to trade were assets. Your Lordship asked, first of all, is it common ground that they had economic value? Ms. Carsfris said, I can't see how it could not be common ground. It isn't, I can assure you. And then my Lord said, I see that. Secondly, were they assignable? To which the answer was, yes, let's just say I'm not aware of a reason why they wouldn't be. Although we would say that if you look at cases such as Solaria, that have analysed earlier cases such as Murungara, it's clear that although assignability may be a factor, it's by no means necessary quality. In our submission, the claimant has the burden to establish that it has a possession. It's not good enough in the court in the administrative court just to say, well, we can't see why we shouldn't have assignability or economic value. None of this has been pleaded. None of it was addressed in the court below. And simply to say, well, in this court, we can't see why these things shouldn't be assignable and have economic value, with the greatest respect, simply isn't good enough. We absolutely do not accept that contingent agreements to trade have any economic value. They're just not an asset in any meaningful sense. They impose administrative responsibilities on the clearing member.
Are you saying, Mr. Crowe, that the essence of the argument below was based on legitimate expectation?
Yep.
That's why the divisional court expressed itself as it did.
Yep.
And insofar as that's the foundation of the argument for the appellant in this court, you don't have any objection to that?
No. Absolutely. I think, in fact, to take the encouragement to move forward, that's probably all we need to say on possessions. Interference, I can be relatively brief with, because what we wish to urge on you appears in the Divisional Court's judgment at paragraphs 242 to 249, and in our skeleton at paragraph 92. Essentially, the analysis that we offer is that Elliott made, and this is the one area, I think, where the contractual context does have traction. We say there was no relevant interference within Article 1 of the first protocol, because Elliott made a voluntary choice to trade on the LME's venue, and as such, any rights it has were defined by the regime of the LME's venues. One feature of that regime is the cancellation power, and as a result, Elliott accepted as a condition of its trading that transactions it entered into could be cancelled by a lawful exercise of that cancellation power. And we say that is why this case is entirely different from the compulsory purchase order cases and things like that, where somebody has a vested property right, which is then taken away by a public authority under some generally applicable law. This situation is entirely different, because by consent, Elliott only acquires that which the LME rulebook gives them.
Do you go further and say that Elliott made a voluntary choice to trade at a time when the market was in fact disorderly, and when a trader might reasonably foresee that the LME would take that view?
Absolutely. And in fact, we would get to that point in two stages. The first is it made a truly voluntary decision to trade on the LME at all. One of my learned friend's arguments was to suggest that Elliott had no more choice than somebody who wishes to provide financial services and therefore is regulated by the Financial Services, the Financial Conduct Authority. That, in our submission, is just factually wrong. Elliott did not have to trade on the LME. Didn't have to trade in nickel at all, but if it wanted to trade in nickel, it could trade over the counter, or it could trade on the Shanghai Futures Exchange. It may well say, well, we don't so much like those because they don't offer the counterparty risk management that the LME offers, which is the whole point. The whole point is that if Elliott wants the advantages of trading on the LME, it has to accept the conditions upon which trading on the LME is offered. One of those conditions is the fact that cancellation may be made, and it was clearly the investment strategy, picking up my Lord Justice Mayall's point, it was clearly an avowed part of the investment strategy on that morning to take advantage of an wholly aberrant market condition. So for the overall sort of structural reason that they chose to trade, and for the specific reason that they chose to trade that morning, intending, putting it crudely, to make a killing out of what was happening abnormally, in our submission has real significance in the court's analysis as to whether or not there was any interference within the meaning of Article 1 of the First Protocol. I think you've already been taken. I think one of the points made sort of almost in a footnote is that Elliott says, well, we don't actually have a direct contractual relationship with the LME, which is true because they're not a member. But it is a requirement of the LME rulebook that a member will, as part of his terms of condition with the in terms of trading with his client, require the client. So in fact, I think we may just have looked at that in Trading Regulations 2.6.4 and 2.10.1. It has to be one of the terms of the arrangements between the member and his own client that the client is accepting that the trades are conducted under the terms of the LME rulebook. Essentially, that is where we go in relation to that, and that is why we say that the divisional court's analysis of the legal position was entirely correct. I won't go to it now in the interests of time, but can I urge on the court the case of the money markets and the London Stock Exchange, which is Supplementary Authorities Bundle 1, tab 11, page 3. The paragraphs I want is paragraphs 141 and 142, which is at page 431.
What's the point?
The point is essentially that what had happened, just to describe it, so Money Markets International was a company that was a member of the London Stock Exchange at a time when the members of the London Stock Exchange had a share each. It failed to comply with its obligations and it went into liquidation. And under the rules, it forfeited its share. And then about a week later, the LSE was demutualised, and everybody who held a share in it made a considerable amount of money. And the liquidator of MMI turned up and said, well, that's a little unfair because we've been expropriated unfairly. And the answer, the legal answer was, you were expropriated under the terms under which you took the share in the first place. So you cannot complain about an interference under Article 1 of the First Protocol. So that, I think, and we do get the other case that the Divisional Court mentions is Sims and Decorum, which is just a landlord and tenant case, which is Core Authorities Bundle 2, tab 15, page 898, paragraph 15, where a joint tenant was complaining that under the terms of the joint tenancy, the other joint tenant had served a notice to quit, which was effective, although he didn't know about it. As a matter of landlord and tenant law, it was effective. And again, the court said, well, that's the deal you signed up to. That is the content of the rights you have. And so you can't complain under Article 1 of the First Protocol. And the point that the Divisional Court make, although obviously the facts are a million miles from this, but the Divisional Court again said that in terms of comparisons, our case is stronger for saying that Elliott can't complain about an interference, because poor old Mr. Sims was a private individual who probably never even read the lease, whereas Elliott are they're big boys. They can look after themselves, and they're trading in a very sophisticated market, clearly opportunistically. And so, in our submission, Sims is a genuinely useful comparator. So that's interference. Lawfulness is not going to take long. Millennium had two arguments on lawfulness. One was to say that if the cancellation decision was unlawful as a matter of domestic law, then it obviously can't satisfy the lawfulness requirement under Article 1 of the First Protocol, and we entirely accept that. We say it is lawful under domestic law, and we have nothing more that we need to say under that. The second argument my learned friend runs under this heading is to say that even if the cancellation decision satisfies the domestic law requirement for lawfulness, nevertheless, the cancellation was not sufficiently foreseeable for the purposes of satisfying the in accordance with the law test under Article 1 of the First Protocol. So far as that is concerned, our answers are an adaptation in the sense of what we said in relation to the common law requirement. We say essentially by reference again to the Sunday Times case, paragraph 49, which I don't think I gave the reference before. It's Supplementary Authorities Bundle 1, tab 4, page 102. We say that the ECHR is not so unworldly as to expect a public authority to be able to define prospectively every circumstance in which it may exercise a power that might impact on people. And secondly, we do also say, and I just want very briefly to go to one authority on this, we do say that what is required in terms of certainty and foreseeability very much depends upon the circumstances in which the measure exists, and in particular the status of those to whom it is addressed. And obviously we say that that has particular significance in relation to a very technical area of activity in relation to highly sophisticated and well-resourced market actors. And the case that we refer to in support of that is Visnish and Latvia, which is in the Supplementary Authorities Bundle 3, tab 28. Just while you're getting that out, I would just explain that what had happened, the dispute arose out of a state expropriation of land in the port of Riga. And in that case, interference actually was admitted, and the only question was justification. But the court dealt with the question of whether or not the interference was in accordance with conditions provided by law, and it expressed some useful guidance on that. If we could go forward to page 1152. At the bottom of that page, you'll see the heading, subject to the conditions provided for by law. Could I just, in the interest of speed, could I just invite your lordships to read paragraphs 95 to the end of 97?
It's really just the second half of 97.
Yeah.
Okay? Well, that's all.
So obviously our submission is perfectly straightforward. We say that the ECHR requirement
already, yes.
Yeah, got that. Okay, fine. So that, I think, is all we need to say on the requirement of lawfulness, which brings us on to justification and fair balance. There are a number of points under the heading of the overall heading of justification itself. I just wanted to tick off the points as we go. My learned friend's argument, at least in its skeleton, is actually under three headings. So I can deal with two of them very briefly because they weren't developed orally, but I just want to tick them off as we go. So the three headings in Elliott's skeleton are legitimate aim, rational connection, and fair balance. Legitimate aim, so far as that is concerned, the points that we would make are that protecting the integrity of the market against meltdown is self-evidently a legitimate aim for an organisation such as LME, and if necessary, LMEC. We've cited James in the UK in support of the proposition that the concept of the public or general good under the ECHR is not only restricted to the entire nation. It is sufficient if the public good being pursued is the benefit.
Well, this is all in your skeleton.
I'm sorry?
This is all in your skeleton.
Yeah. So I think that point certainly will be. And in our submission, the legitimate aim, or the aim in this case, clearly was legitimate. Second point, rational connection. Was the cancellation, did the cancellation decision pursue, was it rationally connected? In our submission, again, that is not something, well, it's not something Malone Friend developed orally, and the arguments in Mr. Holbrook's statement, which really go ostensibly to support it, are mere assertions that the cancellation decision somehow undermined clarity or confidence in the market, or that it created perverse incentives encouraging those who perform badly to expect to be bailed out. I mean, that is just rhetoric in our submission, that the LME did what it did in wholly abnormal circumstances. No bad trader, unlucky trader, can expect anything on the basis of a one-off decision such as this. There clearly was a rational connection between the aim that was being pursued and the measure that was taken. There is also a sort of an attempt to re-ventilate the argument that Elliott made that LME's business is not to worry about systemic risk anyway, but that's a purely sort of national varies point. If it doesn't work there, it doesn't work in relation to the ECHR either. So we get to the meat of the justification heading, which is fair balance and proportionality, however you want to put it. And essentially, the law isn't remotely in dispute. The question is whether or not a decision was taken under which Elliott had to endure a disproportionate burden. So far as that is concerned, what we say essentially is that given the pleaded case on irrationality under domestic law, there is, in a sense, nothing more to be said in relation to proportionality. If, subject to one point, which I'll come to in a moment, there is nothing more to be said on proportionality because the argument on irrationality was that the LME, irrationally, rejected option 1B, a less intrusive measure. And if one looks at paragraphs 82 on irrationality and 110 on disproportionality in the re-amended Statement of Facts and Grounds, you'll see that there is essentially an identity between the way in which the irrationality argument and the disproportionality arguments are advanced. And that, Malone Frenet wishes to say something.
Well, Lord, I'm very sorry to stand up, but I am increasingly concerned about the time. We were going to have 45 minutes to reply. We were 15 minutes over, I believe, in opening, so we had banked on having at least 30 minutes, and I'm very concerned that we're not going to get that.
I'm sure Mr. Crowe will be sitting down in 5 minutes, and we may be able to sit a little bit later at lunch, but not much. I haven't done the stopwatch to see exactly how much longer you've got, but the points are pretty well out there. So let's...
I will be sitting down in 5 minutes.
Right.
as I say, there was, and indeed nothing more was said by the divisional court on the assessment of proportionality beyond its assessment of irrationality, because the two arguments were coextensive. The argument under proportionality is, was there a less intrusive measure that could have been taken without compromising the...
Right, well, you made that point.
Yeah. So what we wanted to say, I don't think we want to go to any case law on this, because I think it's all covered in our skeleton, and I don't need to expand on it.
You said there was one, I think you ought to address is, you said there was one respect in which on the appellant's case there wasn't a complete overlap between proportionality and rationality. What point is that?
That is the new argument that Malone Friend came up with orally yesterday, which is that LME Clear could have margined by reference. So when pressed, I don't have the page. Oh yes, it is. So data. If you want to go back to the transcript, it's the transcript for yesterday, page 44.
Well, we haven't had the transcripts yet, but we will get them.
We'll get them. Okay. So as and when, it's day 2, page 44, lines 23 and following.
Well, my lords obviously have had them. I don't know why I haven't. Okay, I'll sort that out.
But essentially,
what's the point?
The point was, when Malone and Friend got to the point of less intrusive measure for the purposes of Article 1 of the First Protocol, one of the judges, I think it's your lordship, said this is option 1B. To which the answer was, well, it could have been something else, because in order to achieve a proportionate result under Article 1 of the First Protocol...
Is this a compensation point?
No, this is margining by something else.
Yeah.
So the suggestion was floated that in order to achieve a proportionate outcome, LME Clear could have margined not by reference to the Monday closing price, but by some other price of its own invention.
Yes.
For the purpose of achieving a fair outcome. And in our submission, A, that has never been pleaded. It was never argued in the court below.
Okay.
And it is self-evidently wrong, because LME Clear must, under Article 41 of the UK EMIR, it must margin by reference to its potential exposure, not by reference to some attempt to achieve justice for some aggrieved trader.
Very well, we have the point.
So, and that's covered, if you wish to have it, in Farnham 3, paragraphs 28 to 30. The only other points we just wanted to emphasise is that...
Well, if we're just emphasising points, we're out of time.
Okay, I'm not... I am giving emphasis to a point I haven't yet made, which is that one of the important considerations when a court's looking at proportionality is whether the decision maker did or didn't apply their mind. Malone and Friend said, by way of oral argument, that Mr. Chamberlain didn't think about it. He did. He didn't have Article 1 of the First Protocol in his mind. He's not a lawyer.
No, I understand.
But his paragraphs 223 and 226 to 227 of his first witness statement make clear that he was avowedly conducting a balancing exercise, considering whether the known disadvantages to traders who would have expected to make money would lose money, but he thought that the benefits of the decision outweighed those disadvantages. The only other point that I haven't covered is absence of compensation. That didn't feature in Malone Friend's skeleton in this court. We would have had authorities that aren't in this court. Jan and Germany was cited in the court below, as was Mago and Bosnia and Herzegovina, which we don't have in front of you, which gives some flesh to the significance of compensation. The only thing that we would say in relation to this is that reference was made to Trading Regulation 17.
I think you mentioned this earlier. The point, didn't you?
I found it is in fact in the bundle, although nobody's addressed submissions to it. It's Supplemental Core Bundle 14, tab 311.
I think we're not going to go to it.
No, you're not.
You are out of time.
Okay, fine. The only other point is just that in relation to the Human Rights Act, there is the same question about who is the proper defendant. as I addressed in relation to, this is the sort of LME Clear margining decision and the LME cancelling decision.
Is there anything either of my lords want to ask? No, thank you.
I'm grateful.
Yes, Mr. Charles Frisk, well, you'll have to cut your rate according to your cloth, but we won't hold you to exactly 1 o'clock.
I'm grateful. Dealing first with the proper approach of the appellate court, my learned friend effectively said, oh, there should be deference to the divisional court because really what they did was akin to an exercise of discretion. That is plainly not right. We say the proper approach may be derived from the Dalston case that you have seen, applying that in the context not only of the proportionality analysis, but also in relation to rationality. Not asking you to turn it up, but it's really paragraph 36.
Thank you.
The test is whether the divisional court was wrong, and in assessing whether it was wrong and whether the outcome was wrong, you are not confined to looking at whether there was an error of law or indeed whether they reached a conclusion which was not reasonably open to them. So that's obviously an important point in terms of the approach to our arguments.
That's very helpful, if I may say so. But you accept, I think, therefore, as was said in Dalston, that this court does not simply substitute its own view for that of the court below. In other words, it's not a rehearing, it is still a review.
Yes.
But according to the standards you just outlined.
Exactly. Yeah. Obviously, when it comes to proportionality, then the position is different because the divisional court did not assess proportionality in this case. That is where you're effectively placed in the shoes of the lower court.
Thank you.
So far as the point of principle on the contractual context is concerned, my learned friend has not attempted to defend the position adopted by the divisional court, and we invite you to agree with us that there was indeed an error of principle in the approach they adopted. Mr. Crow's tack was to seek to minimize the impact of that error of principle, and say it didn't, suggest it didn't matter so much. But for reasons we have already given, it is clear that the whole judgment is riddled with references to the contractual context and to Elliott's consent. So it was a point that was not only wrong, but incredibly important for the judgment, and we invite you so to recognise. So far as our ground 2, ultra vires, is concerned, there is a small number of important points in our submission. My learned friend said that we were trying to rely on RTS 7 to derogate from the point in Article 48.5 about having a power to cancel in exceptional circumstances. That's not what we were seeking to do. We were relying on RTS 7 on the basis that Article 48 itself, in Article 48.12, set out that ESMA was to, and these were the words, further specify the requirements. That's not derogating, that is setting the parameters or further specifying. Well, my learned friend, of course, said if you go to RTS 7, Article 18, it doesn't actually exhaustively define the circumstances of cancellation. You have our submission on that. But the other point we made, which wasn't met, was that given that we're told that TR 22.1 was intended to give effect to the regulatory framework, it would be surprising if that power, the domestic version as it were, or the LME version, didn't then reflect the parameters of the requirements as further specified by the delegated legislation. Well, then the point was made that RTS 7 just doesn't apply in respect of LME Smart, which is where the Elliott trades were recognized. This is the idea that it was just directed at systems through which one trades algorithmically. But that's not right, because RTS 7 places requirements on trading venues that enable algorithmic trading. A trading venue for these purposes is the same as a regulated market, and one gets that cross definition from MiFID itself. See Article 4.24 of MiFID, not suggesting you should turn it up. And the LME is a regulated market, one of 5, as mandated to appear on a list that the FCA maintains pursuant to Article 56 of MiFID. So what we have is the LME as a trading venue and a regulated market, enabling algorithmic trading because it has a system that does that, i.e. LME Select. The fact that it also has a system or systems that don't do that is neither here nor there for these purposes. And the other point that my learned friend didn't meet here is that given that Article 48 of MiFID, which is the source of RTS 7, does not simply focus on algorithmic trading, it would be surprising if RTS 7, which does that important thing of further specifying the requirements of Article 48, it would be surprising if that were then limited to algorithmic trading in the way that's been suggested. So far as, and I'm sorry, on that basis, then of course Article 18 of RTS 7 applies. So far as Article 18.3 is concerned, the requirement to have a published policy, my learned friend said, well, you can't define exceptionality. And I suspect the court has our point, which we made in looking at A1P1 foreseeability and requirements of that, that it may be that one can't always exhaustively define a requirement or criterion. But here you had a complete lacuna. You had nothing by way of policy to tell persons such as my clients that their trades might be cancelled in the circumstances here. Now, of course, we don't accept that the reasons for cancellation here were valid or rational reasons within the regulatory framework, but assuming against ourselves that they were, well, there was certainly nothing to set out that those reasons might come into play. So there was certainly scope for Article 18.3 to have real purchase here. And it would be odd, and my learned friend didn't meet this point either, it would be odd, as we said in opening, if Article 18.3 didn't have a broad requirement. If it's right that cancellation powers can go broader than as set out in Article 18.2, then given the emphasis on transparency in MiFID itself, and of course also in convention case law, it would be very odd if 18.3 didn't then have purchase on any cancellation power. Moving on then swiftly to procedural fairness. My learned friend had to accept that as per Osborne and the Parole Board, it was an issue for the court to decide whether the duty of fairness had been discharged. And as we understood it, we had now arrived effectively at a position where it was accepted that a duty of procedural fairness prima facie applied, subject to that point about practicability, where also it was accepted, as no doubt it had to be, that any argument around practicability would have to be very closely scrutinized by the court. And then there was the question of, was it necessary to invite persons such as my clients to make representations? And we do say it is inherent in the duty to afford an opportunity to be heard, that it is made clear by the decision maker that they are willing to listen to the relevant party. There must be in that sense, an invitation. And no explanation was offered by my learned friend as to why that wouldn't apply a fortiori here, where we're not talking about general consultation for public participation, but we are talking about individual parties whose protected interests stand to be detrimentally affected. The British Blind and Shutters Association case that I mentioned, paragraph 53, no need to turn it up, it's Supplementary Authorities tab 39, but that case provides strong support for the idea that you need to make clear if you're prepared to listen. And as to the position here on the facts then, much was sought to be made of the LME's notice of suspension, notice 2252 that you've seen at tab 11 of the core supplementary bundle, page 291. And it was suggested, well, there it was, people were told that a decision was going to be taken about the trades. Well, there is no suggestion at all, there's every suggestion to the contrary, that the LME intended through that paragraph in the notice to invite representations. Of course, their point is it wasn't necessary at all to afford such procedural fairness. And they cannot now be heard to say, therefore, that they discharged their duty of procedural fairness through a notice that was never ever intended to do that. In any event, it is clear that the notice is in very limited terms. Paragraphs 9 and 10, if anything, are inconsistent with the idea that the LME is inviting representations. It's, of course, addressed only to members of the exchange, albeit that it's true, as the evidence shows, that it would have come to the attention of persons such as
Well, it's formally addressed to members and other interested parties. That's what it says at the top.
Para 10, yes. Para 10, my lord, is only addressed to members
Exactly.
where it talks about
Contacting your relationship.
and asking questions, very specifically
Yes, I
asking
see.
questions. So, reading paragraphs 9 and 10, one would be forgiven for thinking that actually here is a decision maker saying, well, this is what we're going to do, and if a limited group has any questions, well, fine, but it certainly doesn't indicate a receptiveness to representations. And just in brief response to a point my Lord Justice Singh put to my learned friend, we would say it really isn't a relevant distinction that this case is not like, I think, the Fired case that was mentioned, where you have, as it were, a decision maker and then one particular party and that kind of relationship. What matters, surely, is the seriousness of what was at stake and the consequences that could follow. That is surely the point, the gravity of the issue. So the fact that you may have a larger group of persons who stood to be affected should not in any way undermine here what otherwise would need to be done to afford an opportunity to make representations. Turning then to our irrationality grounds, grounds 5 and 4, just a small number of overarching points. A lot of time was spent by my learned friend shooting down targets that weren't actually targets in the sense of points we had made, and then, I'm not intending to be rude, failing to respond to points we had made. Important that so far as Tameside and rationality is concerned, we put our case in terms of procedural irrationality, if you like, as you will have appreciated, relevant and irrelevant considerations, failure to undertake sufficient inquiry. And we say my learned friend failed to grapple with many of the points we made there. Now, very briefly, as to the particular arguments, need for Mr. Chamberlain to consider what the causes. I'm hoping, my lord, that I can carry on for a little while.
Yes, well, I said you could.
I'm
I
grateful.
will
So
start to look tetchy when I judge it right.
I shall look out for that. the need to consider the causes behind the price volatility. Well, my learned friend said, well, the divisional court said Mr. Chamberlain's approach was all right, so that's that, you're shut out of that argument. But of course, our argument was that on his own approach of saying, were there any rational causes, you had to look at the causes to eliminate rational causes. And it's important to have in mind when looking at the facts and circumstances here, the divisional court itself said at paragraph 110 that no one suggested that price volatility was in itself enough to amount to disorderliness. And that's important when you consider the repeated references here to the unprecedented price rise on the 8th of March. In fact, the evidence before you, see Holbrook 1, paragraph 63, is that there had been comparable price volatility encountered previously in commodity markets, and what was really unprecedented here was what we call the LME's complete overreaction in then cancelling trades freely entered into. But still on the topic of Mr. Chamberlain's finding of disorderliness, it is important that it was very much part of the respondent's case that he was entitled to proceed and did proceed on the basis of this disconnect between the physical price and the derivatives price. And my learned friend sought to distance himself from all of that and indicate that, oh, that wasn't actually part of the case. No doubt because he wasn't able to point to any evidence on that topic as to the disconnect. But, and I will just give your lordships the references, it is clear that that was very much part of the case. It was something the divisional court attached a great deal of significance to, and we invite you to find there was no basis for the divisional court's finding on that or for Mr. Chamberlain's conclusion on that. So, respondent skeleton in the divisional court, paragraph 24(2), and our skeleton, paragraph 52. Also, Mr. Crow's submissions in the court below at day 1, page 143. And
Sorry, Dave, what's this a reference to?
it's the transcript of Mr. Crow's submissions in the court below day
Didn't
1.
even know we had those. You said
I'm
them.
just handing up the relevant passage, if I may, and it has been given to my learned friend. It's just as a specific response to the point taken yesterday.
What's been given to me, it's actually day 2.
I'm sorry.
I didn't think I opened the case.
In the time available, may I invite your lordships
We will read it later.
Yeah, to
What
read
lines?
that at page...
Which line? Page 143. Which lines?
sorry,
Or is it the whole of page 143?
1 to 7.
Okay.
Thank you.
Right. Where do we go next?
We are going to our ground 4, logical inconsistency.
Yeah.
Not disputed, Mr. Chamberlain took the alleged logical inconsistency between trades entered into in a disorderly market and not cancelling them. Not disputed that he saw that as being required by logical consistency, i.e. that they should be cancelled because they had been entered into in a disorderly market. Accepted also that it wouldn't always follow that trades entered into in a disorderly market would have to be cancelled. That was accepted. But then it was said, well, here it was all right for Mr. Chamberlain to apply that reasoning because of the degree of disorderliness. Well, we say that can't be right. If it isn't a legitimate and rational framework within this, legitimate and rational consideration within this regulatory framework, then the degree of disorderliness can't help it. Similarly, as to our point that Mr. Chamberlain wrongly took into account what he saw as there being an inextricable link between the trades standing or not standing and the price at which to margin, wasn't disputed that that was a basis on which Mr. Chamberlain proceeded. And with respect, we say our point just wasn't met, that there is no logical, inevitable connection between whether recently entered trades, trades that have been made recently, whether they stand or not, and the price at which to margin. You have our point about that. As to option 1B, what Mr. Crowe said at the transcript page 114, he said that the respondents took the view that, and I quote, there is no better alternative out there for margining the market during its period of suspension, referring there to the price, the 7th of March price, at which the decision had been made to margin on the 8th of March. No better alternative out there. Well, it means then that it was rightly accepted that was the price chosen to margin, and no doubt there was, in fact, on the evidence, no option but to accept that, and you have the point, they then continued to margin at that price until the market resumed. Well, that was, as you know, we say, a highly relevant consideration, which was really not taken into account at all, and we say it was plainly unfair, also looking at it through an A1P1 lens, for the LME to say, well, we have this price, we do use it for the existing trades, but we're just not going to use it for the 8th of March trades, thereby, as they saw it, being forced into cancelling those trades and putting, as we say, very much an excessive burden on my clients. Moving on then to possessions under A1P1. My learned friend, I think, as I understood it, sought to suggest, by reference to paragraph 234 of the judgment, that we had not in fact put the case on possessions in the court below, as we have done before you. And I'm afraid we've done some digging again in the transcript, and if I may, I will hand you another little bit of that transcript, which we say does make it very clear that we were putting...
It makes more sense to hand them all up at once, but there we are.
I'm sorry, my lord.
It would have made more sense to hand them all up at once. Are there any more you're going to be referring to?
No, this
Okay,
is
right.
this is the sum total. I'm sorry about that, my lord.
Yes, don't worry.
So it's pages 46 to 47.
It's not worth spending a lot of time on this,
No,
is it? Because
I
he said that he wasn't taking any point on it. But there we are. Where will we find it?
So page 46, starting at line 24, a question from Mr. Justice Swift, and then up to paragraph 47 down to line 17.
Okay. Right.
My lords, in summary, try as he might, we say my learned friend has not offered you anything to undermine our analysis as to the very real value of agreed trades and contingent agreements to trade on their own as possessions, or, if need be, with a cast iron legitimate expectation of proceeding to become client contracts. It doesn't matter, and my learned friend certainly accepted that this was not in any way a precondition. It doesn't matter whether they were assignable or not. That is not a criterion. And it doesn't matter whether all steps had been taken by the counterparties to register the trades before or after the suspension or the cancellation decision. I think it's right that the steps had been taken before the cancellation decision, but when it comes to the suspension decision, which of course came earlier, I think only one counterparty had taken the requisite steps. But it doesn't matter. Either way, the performance of the contract was interfered with through what the LME did, or our enjoyment of the fruits of the performance of the contract was interfered with. What was done interfered with the peaceful enjoyment of our possessions. So far as interference is concerned, my learned friend in the last few moments of his submissions appeared to be suggesting a new kind of choice that would somehow prevent there from being an interference, i.e. that Elliott chose to trade when the market was disorderly. Well, I must put down a marker. There's absolutely no evidence of any such choice or as to Elliott's belief that the market was disorderly. In any event, there was absolutely no foreseeability, as I've said, or ability to predict that there might be cancellation in the circumstances of these trades, given the complete lack of any relevant policy. And in any event, even if if there had been such a choice, it certainly wouldn't affect the standards of public law or the question of whether there was any interference. And I'm very, very nearly at the end. So far as
given
policy,
how short Mr. Crowe was constrained to be, there's not very much you need to reply to.
no. I should just make this point. There was, to us, extraordinarily surprising reference to the order cancellation policy. My learned friend said something like, well, as a very last resort on the question of policy, here is a policy which applied.
Yeah.
That was tab 17
Yes.
of core supplementary bundle. And the reason I express such surprise and astonishment is that it has been absolutely fundamental to this case throughout and recorded, and I'll give you the reference in my learned friend's skeleton, absolutely fundamental that it was common ground that there was no policy that covered the circumstances in which the LME chose to cancel our trades. That's why we've had all this debate around, did they need to have a policy?
Well, we've seen the policy and we can see what you say about that.
And you'll be well aware that although Mr. Crowe keeps saying, well, we only had orders, I've already given you the reasons why we absolutely had transactions, and the power to cancel transactions in that policy certainly did not apply. But there is a really important procedural point in this. It would simply be wrong for so many reasons for my learned friend to be allowed to suddenly change course in that sort of dramatic way at this point. There's a specific record of it being common ground. There was no applicable policy. In the skeleton of the LME below, paragraph 16.3, and that's core tab 21, page 492.
Right. Well, I think you're there, aren't you?
I am there. You have our submissions on proportionality, and I would just, very, very last sentences, just invite you to consider the consequences if the respondents' submissions are right. In terms of really, we urge you to think, allowing a kind of free-for-all where the LME would have free rein to take very draconian decisions with very serious consequences, including potentially interfering with fundamental rights, with huge discretion, no policy, and no procedural safeguards. That is a big thing. And to the extent that one might say, well, chuck in the balance that there might be significant consequences if you went in our favour, including financial, well, that of course is something that would then need to be looked at in separate submissions in due course if we went there. But
We have the point.
yeah, may I just make sure that no one is tugging?
Well, tough if they do, because you've run out of time.
I know this is going to
Thank
annoy
you,
you,
my
but
lord.
It is.
can I just say this, that my learned friend's surprise surprised me because we pleaded reliance on the cancellation policy in paragraph 96 of our re-amended detailed grounds of defence. It is not a new point.
Right?
But my lord, I have
We've
to...
always said there was no single policy that covered the entirety of the decision.
Right,
Because
we
the
have your
decision
point.
covered
Just give me the reference, re-amended
detailed
grounds.
grounds of defence, para 96, core
Yep.
bundle 2,
Yeah, just para
96.
96. Okay?
My lord, at
You've
the
got the
risk of
last
the
word.
room exploding, what was pleaded was that the way the cancellation decision was put into effect was in accordance with this policy. It has never been said that the circumstances or reasons for cancellation here were covered by the policy.
Well, thank you. We can, to the extent we think it important, we can read the pleadings and skeletons below for ourselves. Well, thank you both, but not just both, all of those behind you, several rows behind you, for the obviously very hard work that's gone into the very comprehensive submissions we've had. We will, of course, be reserving our decision. In view of the hour, I'm not going to deliver a little explanation of the processes whereby a draft judgment is circulated. You're all very familiar with them. But please, and this is particularly important where we have large teams and large teams within the clients, the initial circulation will only go to those who have been identified to the court on the returns that you have put in. And any further circulation must be for the very limited purposes identified in the Counsel General for Wales case. And you may get into serious trouble if there is any wider circulation of the draft judgment or the contents of it. Thank you all. Yes. Yes. My Lord, sensibly, if I may say so, points out that given that there is there's a confidentiality ring in place, the terms of which certainly I'm not aware of, we will not refer knowingly to anything that is confidential, but please check carefully when you get the draft judgments whether we have inadvertently done so.
We got an email from Ross. She may want to read, so we read out.
Yes, I'm grateful. The listing officer has sent us this. In case the messages hasn't got to you, right, the live stream has now started again. I've put the previous session on private, so no one will be able to see it. I'll edit the video to take out any mention of the identity of the person in question. This could take up to 24 hours. The session will then be made public again.
Thank you.
So whether or not that is actually turns out to be necessary, I think the system, which doesn't mean me, can take credit in dealing with that very effectively.
Yes, absolutely. Thank you very much.
Thank you.
Court rise, if able.
Thank you and thank you.